As per the record, the last time the matter came up, we indicated that we shall be communicating to this honorable court the position of the applicants who are apparently not before you today.
Yes, but what was the position? What are they for what?
Oh, for today, my lord, is for scheduling, my lord. For scheduling.
Scheduling and directions.
For scheduling and directions to be given by this honorable court. Yes, my lord, but we have concerns to be raised, my lord. Again, as per the record.
Are you saying Council Wapo that I don't, court doesn't go ahead give directions and scheduling? Is that what you're saying?
Yes, what I'm asking for, my lord.
Yes. I just want to
is
that
the
matter is coming for this court to give directions for this bill application.
Yes, my lord, the matter is coming up for directions.
Yes, but however, you have some
concerns to raise, my lord. And an application to make, my lord.
About what? That's
the key. Recusal, my lord.
There is a ruling for recusal.
Yes, there are issues that are not canvassed in that earlier ruling.
Okay.
There are issues that were not canvassed in that earlier ruling, and I don't intend to repeat those issues that you addressed in that ruling, my lord.
Under which law now, after the recusal ruling, under which law are you moving what are doing?
My lord, is the Constitution. The Constitution.
Let me capture this. So the concern is about what again?
The concerns relate, my lord, to, if I may highlight the issues. Recusal, my lord. It's about recusal. And it is, my lord, a new application, a fresh application for recusal, which is allowed under the law, my lord.
Under which law?
The Constitution, recusal of judicial officers, practice directions, 2019.
Which rule are you?
Rule 6. I have, my lord, 2 rules or regulations.
Rule 6.
Yes, Rule 6, Sub-Rule 3B. Sub-Rule 3B. My lord,
my lord, apologies. Richard Lee Kumbuka, Chief Secretary, appeared together with my colleague, Joseph Tom Henry. Joseph Tom Henry, also Chief Secretary. For the respondent, Tom Henry. For the respondent. This council,
3B, I will come to 3-1. I mean 6. 3B, Sub-Rule 3B of Rule 6. Where it comes to the knowledge of the judicial officer during the course of the hearing, that for any reasonable cause he or she cannot continue handling the matter, the judicial officer shall state or record the reasons for recusal, notify the parties, and return the file for reallocation to another judicial officer.
I handled that.
No, my lord, this rule is very wide. Provides for any reasonable cause. And my lord,
Read the 8.
Rule 8, 4. Where a judicial officer declines to recuse himself or herself, the reasons for declining shall be noted on the record, and the matter shall proceed for hearing. My Lord, the issue here.
No, I just I'm trying to highlight harmonize with you. This I have looked at 6. We have read 6.
Yes.
3B.
3B.
And I am saying we consider that in my ruling. And I'm telling you to address yourself on 8-4. I gave these reasons.
My Lord, I will also draw your attention to that rule 8 you are talking about, my Lord. Sub rule 1. A party who seeks the recusal of a judicial officer under paragraph 7 shall by letter copied to all the parties and the registrar of the court, or orally in open court in the presence of the parties, request the judicial officer to recuse himself or herself. Yes. My Lord, there is no limit to
8-5. I have finished 8-4. Let us 8-5.
8-5. Where a party is dissatisfied with the decision of a judicial officer not to recuse himself or herself, the party shall state the reasons and the hearing shall continue. My Lord, we are going to state the reasons why we are dissatisfied with your ruling. No, my Lord, 9 is about to appeal. Any appeal arising out of the failure to grant an application for recusal shall be made after the matter has been determined. My Lord, here we are not raising an appeal. We are raising a fresh application for recusal, which is not allowed, prohibited under the law. This is what I'm saying, my Lord. Rule 6 allows as many applications as possible. Yeah, that's what it says. If you have, my Lord, if you looked at sub rule 3B, it is wide. It talks about any reasonable ground, my Lord. That is sub rule 3 of rule 6. Sub rule 3B of rule 6. It gives us wide latitude, my Lord.
So you are invoking rule 6.
Rule 6, 3B.
Relating with what?
Recusal, and we have reasons which are totally different from the reasons that were canvassed in the earlier applications, which are captured in your ruling. We have reasons and grounds, my Lord. We have grounds for recusal, yes, which are totally different from the earlier grounds that were canvassed in that application that you disposed of. Which are totally different from the reasons that were canvassed in the earlier application that you disposed of. And this is a fresh application on fresh instructions. Yes. Yes. Yes, my Lord. I thought I was going to be permitted to proceed, my Lord.
I am saying you can sit. Yes. I want to respond. What you have.
If I may finish the submissions, my Lord, on that particular argument.
So, the issue here you are saying you have an application for refusal raise which is different from the one.
Yes, my Lord.
Yeah. So you sit, I just want to respond. Just before I respond.
can only come from court. And
My Lord, in response to the submission of our senior colleague, the application my Lord is seeking to make was already hard and determined. Doesn't matter whether it has a different reason. The respondent has been on record arguing that this is an abuse of the process. We cannot have the same applications over the same matter, same parties seeking the same remedy. That said, even if it were not an abuse of the process, my Lord, my senior colleague is relying on Rule 6, Sub-Rule 3B. And my Lord, from the reading of the rule, senior counsel has no locus to make an application under that. This rule only applies to a judicial officer. Allow me, my Lord, read it verbally. Where it comes to the knowledge, of a judicial officer, Rule 6, 3B. The application is being brought under 63B.
Yes. Which one are you?
I'm reading B, 3B.
Yes.
Where it comes to the knowledge of the judicial officer during the course of the hearing that for any reasonable cause he or she cannot continue handling the matter, the judicial officer shall state on record the reasons for recusal, notify the parties, and return the file for reallocation to another judicial officer. The English is very plain and clear. It baffles the respondent, therefore, to hear the applicants premise the application on a rule which doesn't give them space. Application all matters before court are premised on the law. There must be a provision of the law that allows one of the parties to institute any application before court. And therefore, my senior colleague should have looked or should have premised his application on another rule, not Rule 6. should it be? In the circumstances, my Lord, it is our prayer that you be pleased to dismiss the application and the main application proceeds.
Otherwise, it is wrong. Otherwise, it is wrong for our senior colleague to impose this rule on you again.
So, otherwise, it is wrong, my Lord, for senior counsel to impose this rule on you, my Lord. It is on your own initiative, evolution as a judicial officer. We so pray.
My Lord, I've failed to make head and tail out of this in submission. Yes, I'm responding, my Lord. And indeed, this is what I'm doing, my Lord. Because the reading of this rule is clear. The 63B, the reading is very clear. For clarity purposes, let me read it again.
I have it. Yes, I have it.
No, for myself now, to substantiate the argument I'm going to make. Where it comes to the knowledge of the judicial officer during the course of the hearing, that for any reasonable cause, he or she cannot continue handling the matter. How does it come to the knowledge of the judicial officer in the course of the hearing if you do not permit a party to bring those matters to your attention? I am here to bring those matters to your attention so that you make a decision that you cannot proceed with the matter. So how else would you know that there are reasons that would bar you from proceeding with the hearing of the matter unless I'm given an opportunity to present the same to you? That's why I'm not making head and tail out of it. That is submission is illogical. It is illogical. Secondly, my Lord, I need to reiterate the earlier submissions I made. That this rule is very wide. For any reasonable cause, that would bar the judge from proceeding with the matter. It's open-ended, it's wide. And my Lord, this has to be read and interpreted against the provisions of the Constitution which grant liberty to any party to raise a matter before a judicial officer. The right to be heard. I don't know why a party to these proceedings would be prohibited, would be barred from presenting their reasons and grounds. And if there is merit, then they are upheld. If court is not convinced, you decide otherwise. And the right to be heard, my Lord, is non-derogable. Under Article 44, the right to be heard is non-derogable. I am not imposing the position of the applicants onto this court. All I'm seeking, my Lord, is that grant us a space to be heard, to present the case of the applicants. And the prerogative is yours to take a decision, one way or the other. So he cannot in any way be heard to assert that I am imposing our position on the judicial officer. No. We want to present our case before court. And then a decision is made one or the other. So it will be a travesty, my lord, as I conclude, for this honorable court to bar us from presenting whatever case we have on behalf of the applicants for court to hear the merits of the same. We reiterate our prayer, my lord, that you permit us to bring these matters to your attention and you take your own decision accordingly. We do so pray.
I have very carefully listened to the submission and what the state has responded. I will now proceed to make the following remarks and findings based on the submission. That I have perused this file, this application, and noted that the application for recusal was made, it was considered by this honorable court, and the ruling was delivered on 19th August, when both declared to recuse, and the reasons are given in that way. Today, when the matter was coming for scheduling and directions, in this state application, Council Pablo raised some concerns and said that he wanted to make another application for recusal. Under Rule 6(3)(d). Now, I will just address myself to Rule 8, Clause 4 of the Constitution of the Recusal of Judicial Officers, Practice Directions 2019. I will quote further. That when a judicial officer declines to recuse himself or herself, the reasons for declining shall be noted on the record, and the matter shall proceed with hearing. This court indeed gave the reasons for declining to recuse on 19th August. My understanding of Rule 6(b), Rule 6(3)(b), which Council Pablo is relying on, I have very carefully looked at it, and the same is addressed in Rule 8(5), in the same directions, which states that where a party is dissatisfied with the decision of a judicial officer not to recuse himself or herself, the party has the reasons and the hearing shall continue. It is my considered view that Council Pablo has already told the court that he was not satisfied with the decision of this honorable court. Hence, he wants to raise other reasons for recusal. My view is that if counsel was not satisfied as he submitted the same has been noted that he was not satisfied with that ruling. And I put it on record that he was not satisfied. And it is my view that since this case was coming for scheduling and directions in this application, I hereby direct that this application will proceed with hearing in the presence of the applicants on 9th October.
No, my lord, before you take leave of the matter, my lord, before you take leave of the matter, I just want to be on record. I have no instruction to proceed with receiving the directions and also participating in the
I
scheduling.
am ordering the registrar
My,
to issue production warrant
my,
on 9th October,
my instructions were restricted, my lord, to raising the concerns.
which I have put.
Yes, but as far as directions are concerned, I have no instructions to receive the same.
No problem. I have directed that I will proceed with this application on 9th. The application will proceed.
My lord, the name is the public holiday.
Already, he is a factors official. He is a factors official. Bye bye.
I will take this matter.
You better have, my lord, this court is not functional official because this court is not functional official. So it's a public holiday. My lord, we seek another date before or after that. Yes, my lord.
Hearing is adjourned. Yes.
Most obliged, my lord.
At 10, at 11,
Most obliged.
PW issue.
You can see his behavior is not concomitant with the dispensation of justice, and it is really disturbing for us. It's a serious matter which touches liberty and life of our people. And these two rights, we have always said, they are the most sacrosanct. The right to life, first, next one is civil liberty. And now you can imagine the way he's conducting himself. Playing around with the people's lives. You call a matter, there are concerns to be raised, and you are not ready to entertain them. In total disregard of the constitutional provisions, which dictate that the right to fair hearing is non-derogable. When you look at Article 44, one of the rights that are absolute is the right to be heard. So all we are seeking was just audience to be heard, to present concerns of the accused persons, why this matter should not proceed before that same judge. And he was not ready to listen. Can you imagine he made a ruling blocking us from entertaining those matters? The Constitution, judicial officers, whatever practice guidelines on recusal are very clear. They provide wide latitude for any aggrieved party to raise their concerns at any time, at any stage of the proceedings. Actually, the rule we cited and other rules clearly state that in the course of the hearing, you can raise as many applications as possible, depending on the circumstances and the conduct of the judge. If a judge conducts himself in a manner that is not in tandem with the dictates of the Constitution and the conduct of the judges, then you, or rather judicial officers, then you are at liberty to raise those matters. Even if you raise as many as possible, 1,000 applications, it's within the within the purview of the law. Now he has blocked us from raising the concerns of the accused person, whose fate lies entirely in his hands. Because his duty is to listen. After listening, he takes a decision. We had grounds totally different from the earlier ones raised. And the rule provides for grounds which can arise in the course of the hearing. You ask yourself, supposing in the course of the hearing, he makes a sweeping statement which is prejudicial to the rights of the accused persons. and he claims that we are precluded from raising those matters since we made one earlier, which he dismissed, and then that is an absolute ban now to raising any matter concerning his conduct. This is a matter we cannot take lying down like this.
Lord Mayor, what are the concerns? What are the reasons?
The reasons, we had 3 grounds to raise here. Number 1, the file is wrongly before him. The main case is supposed to be before the Constitution, the ICD. The main trial is supposed to be conducted at ICD.
International.
That at International Crimes Division.
Yes.
According to the indictment, that was signed by the DPP. Rather, the indictment, that was signed by the DPP, and the charge sheet in the lower court, the file is supposed to be committed to the ICD. That's where actually it was committed by the magistrate, the chief magistrate of Nakawa, Christine Nantek. She committed the file to the ICD for trial. So you cannot again arrogate yourself powers to purport to conduct a hearing of a matter here when the file is supposed to be, and the application arises out of that matter. That is one. 2, the judge made statements in his earlier ruling that Dr. Besigye and Obedi Lutale are wasting time on applying for bail. Instead, they should concentrate and focus on the main trial. In his earlier ruling on recusal, he didn't say anything about that. He never ruled on that matter, which we are insisting is a matter which clearly brings out his prejudice, that he's biased in this matter. He has a predetermined mind as far as this application is concerned, because when he was considering the application for mandatory bail, he made that sweeping statement, which is prejudicial, that Besigye and Obedi Lutale should stop wasting their time on applying for bail. Instead, they should concentrate on pushing for the hearing of the main case. And he never ruled. Go back and make reference to that application. We wanted to draw his attention to that ruling he made. He never addressed his mind to that issue. So how do I appeal on a matter where you have not made a decision? Even a lay person knows that. A non-lawyer knows that unless a matter is decided upon, you cannot go to an appellate court. So this is a matter we wanted to raise before him. The third one is about the practice of this court. A judicial officer who handles a bail application in the first instance and he dismisses it or declines to grant it cannot entertain a subsequent one. That has always been the practice here. It's the reason when we appeared before Justice Kanya Comfort and she declined to grant Dr. Besigye bail, she never entertained any other application. If it were to be one judge insisting on hearing all the bail applications that we present here, actually this file should be before Comfort. She's the one who had the first one. Why is it that Justice Comfort Kanya is not the one handling it, yet she's the one who handled the first one? So if we are to go by that precedent and the practice in this honorable court, then the very reason Justice Baguma should recuse himself from this matter and say, I've already made my decision on this. Rather, what actually a reasonable judge would do under the circumstances, he would make a decision and say, please, I've already made my decision on this. I have my opinion on whether Dr. Besigye and Obedi Lutale should be given bail or not. And in the interest of justice, I cannot proceed to entertain any other application. Just like a Comfort Kanya did. Our instructions here were to raise these concerns. And it is the reason Dr. Besigye is not here. Now, the judge has made a very, very obnoxious decision that they should appear physically here on the 9th
of October.
9th, yes, for me, I have not heard of any other date, and I don't want to hear anything from anyone. I was there, the judge made a directive, and we are here for directions anyway. That's what he said. He gave a direction that this matter should be fixed for 9th October, which is a public holiday, which he knows actually is Independence Day. And he directed the registry to issue a production warrant for Dr. Besigye to appear on 9th of October. That's the direction he has given to the registry, that the production warrant should read 9th October and that Besigye should be driven here on 9th of October. That's what he said. And but going by his own ruling, if a decision is made by court, they can't change it. That's what he said. That once he has pronounced himself on the matter, yes, like he ruled on recusal. He said he had pronounced himself on the matter, he couldn't sit in his own decision. Now he's shifting the goalposts. In this one, he heard that, hey, he said, hey, now, let me change it. Can you imagine? So, Dr. Besigye will not be here. Let me be on record. Dr. Besigye and Obed Lutale will not be here on that date of 9th of October, which he has set. And the judge, we insist, should take this matter back to the registry for reallocation. That is our position. The position of our clients is very clear that this matter should be sent back to the registry for reallocation to another judge. They are not going to appear before Justice Baguma on that matter. And that is the position. Fe tulemeddeko tugamba Baguma kwata file agize mu registry egende bajuwe judge omulala. Ensonga tuzirina twamugambye ng'ojjeko ziri ze twaleeta n'azigaana olwaleero tuzze n'ensonga endala 3. Esooka main file eri mu International Crimes Division ye ICD teri maaso ge. Era n'ekiwandiiko kye bayita charge sheet oba indictment ekolebwa DPP empaabi baateekamu nti omusango gugenda mu ICD International Crimes Division. Ne Christine Nantege magistrate wa lower court kye yagamba nti file egende mu ICD. Baguma atuula wano alemedde file nga mu kifo ky'ogiweereza mu ICD. Ekyo tetugenda kukikkiriza. Ekyokubiri, Justice Kania Comfort ye yasooka mu musango guno n'asa bail application n'agigoba naga yadde Dr. Besigye otuukiriza ebisaanyizo byonna naye nze nkomye bail. Kakati enkola ya kooti ebaddewo era etakyusibwanga. Omulamuzi asooka kasita akumma bail toddayo mu maaso g'omulamuzi y'omu. Tubibaddemu bangi emirundi mingi. Ne bwe twali mu gwa Ssewanyana ne Ssejjirinya Masaka gwasooka wa Justice Victoria Nakintu bwe yaba mu bail gwagenda wa Justice Nsengundi Muganza Victoria aba wa bail Jokoke no oluvannyuma Justice Muganza. So ebyo weebito webiri. Omulamuzi asooka bw'akumma bail taddamu kuwulira musango application ndala ye practice ebaddewo. Kati Baguma yagaana bail eya mandatory. Imagine omuntu aganye mandatory bail ate adde mu maaso go ogambe nti agenda kulira gye bagamba eri discretionary nga ye alina okusalawo akuwa batakuwa. Ensonga yakubiri eyokusatu kwe kuba nti nno mu ruling eyasooka mu bail Baguma yagamba Besigye n'Obed Lutale abawa amagezi ebyokwewubanga mu kooti nti basaba bail babiveeko bagende balwane kulaba ng'omusango main case yeewulirwa. Kakati ate oyo atandika atya okulira bail application. Kuba wasazeewo dda nti actually bamala bya mu bulago okwewubanga mu kooti nga basaba bail. So otandika otya okwoleza mu maaso g'oyo n'osaba bail. Kitumugamba nti gwe obanga olina mind eyasalawo edda nti Besigye amala budde okujja asaba bail. Therefore omusango guveemu. Bulekera omulala ye aliredde okuwuliriza. Ekisembayo kwe kuba nti anyoomye ssemateeka. Kitulumye nnyo okulaba nti Justice Baguma anyoomye ssemateeka muyisizaamu amaaso n'olugaayi. Ssemateeka agarantinga right to fair hearing. Eddembe ly'omuntu omuwuliriza omulamuzi alina obuvunaanyizibwa okumpuliriza oba byenjogera birimu amagezi oba temuli magezi, oba abyagala oba tabyagala. Omulamuzi tayinza kugamba sijja kuwulira ŋŋaanye. Eye wuliriza ensonga zaffe ze tuleese. Bakirayants bali luzira tebaliiwo. Batutisse tuli ensonga tuzireete tuziteeke mu maaso go okusalawo okuku. Era tutwagala mukakaaza n'asalawo atula naye n'okutuwuliriza agaanye nti sijja kuziwulira. Ekyo tekiriiyo. Kakati ezo ze nsonga zennyini ezikulaga nti eno terigiri bwenkanya mu maaso ga omulamuzi oyo Baguma, era ffe ensonga zino tugenda kuzongerayo okulaba nga Baguma ava mu musango guno gugende omulamuzi omulala. October tubadde tetuliyo sinawulirako nga 8 atutadde ng'agambye awadde direction nti Besigye ne Obedi bajja baleeta ennaku z'omwezi 9 era agambye Registre okole production warrant nga baleete nga 9 akizeemu emirundi mingi. Kakati mpuliddeyo abakola olwogolo nti eyo sebo eyo 9th October Independence Day public holiday simanyi birala bizzeeko nzimbadde enfulumye. Kakati direction bw'abanga alina engedala z'akoze azikoze ku lulwe ffe tetumanyi tugambye 9th October katulinde production warrant ya 9th October naye nga Dr. Besigye obviously tayinza kubeera wa Obedi Lutale nga 9 October kuba public holiday ate n'ensonga zetuwadde wano lwaki omusango nalina okugamba.
On you. No, we had left. You say you should put this injustices to order. Put them to order. You cannot be so bogus like that. Let him amend, but you take the record that this is a bogus injustice. A man who has no clue that 9th October, I began to doubt. Is Independence on 10 or is it on 9? Because a man of his age and his stature, not to know that 9th October is Independence Day.
Omusumba ye n'asaba n'agamba bagawukule gagende wakumuluma 13
naye gavumenti yakimukugamira ku mutwe
era mbyagalira ddala pulezidenti wange
be twasaba bajje batusabire tebakoze eki tebalabise
tugenda kwekalakasa paka kulumya